Hello, and welcome to Exhibit A. This is our firm podcast where we invite guests from the community to hopefully provide our family law clients and to the public some useful information. My name is Casey Marticorena. I'm a certified family law specialist with the law offices of Donald P. Schweitzer. I'd like to welcome my guest, Joshua Driskell. Welcome, Joshua.
Thank you, Casey.
Thank you for being here. Joshua is a partner at Lagerlof LLP, formerly Primith, Driscoll, and Terzian. And Joshua, you focus on tax, business, and related matters.
Yep.
And I did a little bit of research, and I see that you do some work, and you serve on boards such as the Pasadena Museum of History and Pasadena Fire Foundation.
I do, yeah. Those are exciting parts of my job.
Interesting. You're not a Pasadena native, but you're very entrenched in our local culture here. That's wonderful.
Yeah. I'm born and raised in Ohio, moved out here when I finally figured out this was the place to be.
Perfect. So we are going to cover divorce and taxes. So dun, dun, dun.
Yeah, two fun topics. Yeah.
Very fun topics. We're going to try to lighten it up. My goal really is to, this is a daunting, scary topic.
Yeah.
And I really want to unbundle some of these basic fundamental tax theories, laws, so that we can really help people out. So as the family law attorney, what I'm doing is I'm identifying issues, I'm identifying assets, and then we're essentially figuring out how we're going to divide everything. We're either going to sell, we're going to, trade, and it's really important to make sure that we're trading apples to apples.
Mm-hmm.
If you have a cash and then you have a house, it could be apples to oranges, and it's really important to look at the tax impact of a settlement agreement. So,
well, sometimes the tax implications are almost always the last thing thought about sometimes, and they can have some of the biggest impact because to your point, you're trying to equalize in a divorce, right? That's typically the goal, or maybe not, but the goal is to sort of get everybody in a position where the divorce will go through, the court will approve it, or everybody's happy with it. And because taxes can have such an implication, you need to look at them almost immediately. Otherwise, you may be in for a big surprise, and maybe a good surprise, and maybe not a good surprise. So it's important to start thinking about it early.
Well, that's great, and I appreciate that because something that I repeat often as a family law specialist is I don't practice tax law. I cannot give you advice. You need to run this by your tax professional. I think that's super important, and I used to think, okay, we'll have the judgment. We'll have, a tax attorney look at the judgment. But what you're saying is, early on, probably in the negotiation phase.
Yeah, I have, and we've worked with your firm and you guys are great. And sometimes the best way to think about it is right when you're actually negotiating, because there may be some things that, the other side may not be thinking about taxes at all. And you may be able to use the negotiation theories that you're working on in conjunction with the tax savings or in conjunction with sort of the goals of the representation or what your client's goals may be, and use the tax law to your advantage in that capacity. The IRS is very tax neutral about divorces, generally speaking. They're not trying to impact someone negatively or positively in any general direction, but the law is there and the guidance is there as to how things will be treated. If you know that going in when you're creating the divorce, negotiations, basically, you're in a much better spot because you're going to be able to really think, okay, if I do it this way, then I'm going to have this tax result. But if I do it this way, I'm going to have a very different tax result. And many times that can be thousands of dollars or a lot of headache later once you figured it out. So judgment might be too late because having me review the judgment is great, and I can always spot issues and say, let's tweak this language here or let's do this. But if I'm involved in the negotiation stage, I can really help.
So the takeaway is seek tax counsel early in the process, basically.
Absolutely.
Perfect. Let's jump into our first topic. I'll give you a very basic topic and a hypothetical. Feel free to adjust my hypotheticals.
To one I can answer, hopefully.
Right. How convenient. So, number one, if you receive support, there's child support and there's spousal support, do you have to pay taxes on the support?
Well, it depends sometimes on your state. Right. So states handle these things very differently. You always want to your point, talk to your tax person early, right, and have them really look at your situation. But generally speaking, we'll kind of speak in a general guideline. This is a tax neutral situation, right? The IRS looks at the payment of support and the receipt of support as a tax neutral. And what I mean by that is that you would not get a deduction if you were married for paying for your kids' shoes, right? You just wouldn't. You don't get that same deduction in this scenario, right? So the IRS says, okay, and this has been changed rather recently in 2018, and there's some laws around this, but basically, if you're making payments on support or you're receiving payments on support, they're tax neutral. You're not claiming, and you're not claiming it as a deduction, and you're not claiming it as income.
So the hypothetical is wife pays husband $1,000 a month in child support and $1,000 a month in spousal support for a total of $2,000 per month. So wife is paying husband. Husband's receiving $1,000 in child support. Does husband have to pay taxes on that $1,000 in child support that he's receiving?
No.
So child support for tax purposes is not income.
Right.
Okay. So how about the $1,000 a month in spousal support that husband is receiving? Is that income for the IRS?
It used to be. And in 2019, the law changed to say that it's not. So you're not going to claim it, and that person who's paying it to you is also not going to get a deduction for it.
Okay. So for our listeners, husband is going to pay taxes on $1,000 a month on spousal support. That was the old law.
Right.
Okay, very good. So now that's kind of a huge change, isn't it?
It's a huge change, right? Because, before it used to be that, when you've got the wife paying the support here, and the alimony essentially, but that always was looked at as, okay, well, at least I'm going to get the tax deduction for making the alimony payment to the spouse. They're going to claim it or whatever's going to happen, but that was always looked at as, all right, well, at least it's coming off of my income. I'm not going to have to pay tax on it. They're going to be saddled with it. Well, now that person doesn't get the deduction for paying alimony. So if you have a significant $100,000 a year alimony payment, it's not an above the line deduction for you any longer. So it really pushed a lot, and you probably saw this at the end of the year. It pushed a lot of people into trying to get their settlement agreements done prior to that time. This area in particular is extremely important to engage the right counsel, because the law is treated differently based on when your agreement was entered into. So if you have a pre-2019 agreement, the rules may be very different for you. Post-2019 agreement, the rules are going to be different as well. So you want to make sure you have somebody in your corner looking at it directly and making sure that everything is done exactly. You're reporting the income or not reporting it exactly like you should.
Okay, so let me follow up on this point. Let's say you have a 2015 spousal support order, right? And the person that is paying the money, they're receiving a deduction,
right? Correct?
Yep. Now, 2020, let's say that person wants to modify that order. The question, from my understanding, it's a gray area. You can comment, but what the question that everyone has is, am I grandfathered in on this spousal support income deduction? Am I going to get a break here, even though I'm modifying in 2020? And from my understanding, it's a gray area. Yep. What do you think?
We haven't seen the IRS release really guidance on this yet. It could come out. The IRS releases guidance in a lot of different ways. Sometimes they just publish it. They say, this is what we're going to do. They get ahead of it. This is an area I'm surprised they haven't done it, but that's a common area. We're going to publish. We're going to say exactly what we're going to do. They did this with the Section 199 deduction, the self-employed S-Corp deduction. They really got ahead of it and pushed out exactly what they were going to do, because they knew otherwise their phone lines were going to be blowing up for 6 months. They haven't done that here. But so the IRS does it with that kind of guidance. Sometimes they do it with private letter rulings. That would be like me or you writing into the IRS saying, hey, I have this fact pattern. How are you going to treat it? Are you going to audit me? And what would you do if you did? And they will, for a fee, respond and say exactly what they're going to do. So you can use private letter rulings for us as practitioners to see, okay, the IRS in this fact pattern is likely to do something like this. Then, of course, there's also people that take it all the way to the tax court. And there's a judge at a tax court that says, no, IRS, you're wrong, or IRS, you're right. This is how you're going to do it. We don't know that yet. So my gut feeling is going to be, based on how the IRS handles settlement agreements generally, that if it's a modification of a prior order, that they're going to respect its prior tax treatment. But if it's a new order, brand new, fresh divorce, it's going to be under the new rules. That would be the most likely scenario for them.
And I found that, speaking with attorneys and judges, and I find that that's kind of the general understanding of what's going to happen. So as a final comment on this point, I do want to say we've been talking about federal law. However, the state of California, according to the state of California, the law has not changed.
That's right.
So if you pay spousal support, it's a deduction.
Yep.
The recipient of that spousal support must pay California taxes. Right?
Yep.
So we're talking about federal versus state here. Thank you for that.
California, and good point. California they tend to align themselves with the federal law over time, but they don't always. For example, with in the business context, they have not adopted the same rules as the federal, the feds did as it relates to meals and income, right? Meals and business expenses, things like that. So California so far has left it alone. They've had plenty of opportunities to change it, and they have not. So to your point, whatever state you're in, whether it's California or anywhere else listening to this, definitely check with somebody local.
Very good. And this reminds me of something important is, our listeners and our viewers may know that there's a Disso Master software that calculates child support. A mandatory guideline in California also calculates temporary spousal support. So there are adjustments in the system so that you can, turn the off button for taxes on federal, state remains on. So something that your family law practitioner is going to keep an eye on and make sure the settings are correct so that when you calculate this, we take into consideration the taxes. So that will lead us into the second topic. A lot of people are really interested in knowing what happens when you're getting divorced and you're transferring property. In general, when you're transferring property and selling property, sometimes there are certain tax triggers. So in our hypothetical here, husband and wife bought a house 20 years ago as husband and wife married in the state of California for $400,000. Fast forward to 2020, the home is now worth $1 million. So big picture, I think this is flagging two issues, capital gains and, whether a tax reassessment will be triggered. So some general thoughts, Josh?
Yeah, no, that's good. That's a good one. So, generally with spouses in general with the IRS, there is no taxable event. It's again tax neutral when spouses transfer things to each other. If two people are married and they say, okay, I own this property over here, I'm going to put you on the title, or I'm going to take you off title to refinance. I'm going to do all of this from a tax perspective. The IRS does not look at that as a sale, right?
As opposed to
selling it to somebody else, right? Where if I'm selling it to you, a non-spouse, I am going to generate, in that scenario, taxable capital gains, right? So really, it's important in this particular situation, right? So, let me make sure I understand your hypothetical too, right? So we bought it for $400,000. It's now worth $1 million. They're getting divorced. Is somebody getting the house in the divorce?
Let's say wife's getting the house in the divorce.
Got it. So husband has to give her, you must have represented her. So husband has to give up his interest. He's living in the garage. We're kicking him out. Okay. So, in this situation, right, it's going to be incident to a divorce. There isn't going to be a taxable implication to the wife receiving that portion of the property in the divorce, essentially, right? It's not going to be considered a sale. The IRS is not going to make the spouse pay capital gains to the divorcing spouse, anything like that, right? But what can happen is wife later sells it, right? She says, okay, well, this house is way too big for me now. I need to sell the house. And that's a different situation, right? You may have received the house in the divorce, lived there for a year or two, and now said, oh man, this is way too big. Or I want to move somewhere else. I want to move to be closer to my parents, or I want to move to be closer to siblings or whatever. That there is going to be some capital gain at that point, right? Because now we're selling an asset.
At that point now, if the house is worth $1 million plus, now wife is essentially absorbing the entirety of the tax on all the increases.
That's right.
And husband got away without having to pay any of that.
That's right. In that scenario.
So in that scenario, you bring up a very, very good point, and that is think long and hard before you negotiate in your divorce judgment whether you're going to keep the home. If you're going to sell a year or two later, it's probably best to absorb, to share in the tax burdens with the other spouse. It should be well thought out. If you're going to keep the home, you're going to keep it, at least to make it worth it,
Right, exactly. Sometimes you see in these types of divorces, well, I just want to stay in the house until Junior graduates, right? Well, Junior's a sophomore. Okay, so Junior has 2 more years before he's going to graduate, and presumably, it's not like mom's going to sell the house the day that he's graduating, right? So 2 years turns into 4 years, and before mom really says, okay, he's not coming home from college as much anymore, so now we're going to actually sell the place. To your point, yeah, you got to keep the house, and that's great, and hopefully the appreciation of the real property's value is going to help in this tax scenario, but it's not going to offset all of the capital gain that you're going to likely have to pay because you aren't a married filing jointly, individual anymore. You're going to be filing as a single person, and you're only going to get to use that $250,000, capital gain exclusion that you receive as a single person. Now, if you get remarried and that spouse, during that period of time, and you have a second spouse that meets the requirements to be able to utilize their exemption, then you may be able to sort of dodge the bullet there a little bit.
What is the difference between the exemption between a single person versus married?
Yeah, so a single person gets a $250,000 exemption for the sale of their primary residence, right? So if I have $500,000 worth of gain in selling my primary residence, as a single person, I can exclude $250,000 of that. If I'm married and my spouse joins with me on a joint return, then we can exclude $500,000.
That's huge.
That's huge.
That's a huge difference.
That's a huge difference, and depending on the state that you're in, that could be, it's many thousands of dollars. It's certainly a consideration that should be made. Sometimes I've seen in divorce settlements too, taking into consideration the tax that the spouse is going to have to pay, right? So if we know that that wife is going to keep the house for 4 years, and it's a foregone conclusion that she's going to sell that house when Junior graduates, maybe we make an adjustment or an allowance for that in the divorce decree to say, well, we know that wife's going to be shouldered with X, Y, and Z debt, and because of that, we are going to go ahead and she's going to also receive this item to offset that tax that's later got to be paid, something like that.
That's a great point, because that's the power of negotiation, because if the litigants go to trial, the trial judge is not bound by what may happen, what most likely will happen in 4 years. The judge is not really going to cut anyone a break on that point. So that really kind of tells people to really use the power of negotiation and realizing that they have a little bit more control if they negotiate their own agreements.
Well, right. And remember, too, that the judge is there as a neutral party, right? He's not going to, in most circumstances, look at somebody and say, are you really going to live in that house for only 4 years? Don't you think you might want to do X, Y, and Z, right? Judge is a person, too. He's really just trying to make sure that the proceedings are fair and neutral for both sides, that everybody's getting something that's going to be, that both sides have been represented by competent counsel, and that the agreement is what they're agreeing to. He's not going to typically pick up some issue that's going to cause a tax burden for somebody in the future. Right. One, he's probably ready for lunch, and two, he's just not going to do it. It's not his job. So, thinking about these things, and to Casey's point earlier, bringing this into play in the negotiations at the beginning is really important, because if we know we're only going to keep the house for 4 years, we can do calculations to tell you exactly what your tax burden is going to be within a few dollars, so, in 4 years, making some general assumptions. If you know you're going to keep it forever, of course, plans change, but then that may factor in as well.
Okay. So then that kind of leads us into asking you to, 1031 exchange is a term that we hear thrown around quite a bit. I'm sure you know all the ins and outs.
Yes.
Okay. So don't scare off our listeners and our viewers, but can you give us kind of the Reader's Digest version of that so that we can understand what that means?
Absolutely. So a 1031 exchange generally is a tax provision that allows you to defer gain, capital gain, on an asset by buying another like kind asset. So the best way I can explain it is with an example. So let's say that we own a building, right? So I have a building on Main Street in USA Town, USA, and that building is worth $500,000, but I bought it for $100,000. Well, if I sell it to my friend for $500,000 or to anyone for $500,000, I'm going to have a gain, right? A $400,000 gain. Well, I can do one of two things. I can either pay all of that gain, or I can exchange my building for another like kind item, right? With the IRS, it has to be a like kind exchange. So I can buy another building of equal or greater value and defer the tax into that building. So I don't pay the tax at that level. I'm deferring it. And if I sell the second building, that's when I would pay the tax. It's important to know that a 1031 exchange does not apply to your primary residence. It only applies to other assets, other real property, or other like kind property. There's many exclusions from a 1031 exchange, but it's most commonly applied to real estate. So this would be, not the family house, but maybe the building that someone owns down the street, or some rental property, or, something like that.
Okay. So for the lay person, What do you think is the spirit behind this? Is this to encourage people to continue to reinvest their money
Yeah.
and own real property?
That's really what it is. Exactly. It's an encouragement for people to reinvest, to continue to be, real property owners, continue to invest in communities, things like that. That's exactly what it's for. And it's been around forever. 1031 exchange has very many variations that have been in place for a long time. I don't see it going anywhere. There's a lot of requirements on a 1031 exchange. For example, you have to involve an escrow company that also can, and also an accommodator. That's a technical position within an escrow company that basically holds the money until you're ready to buy the new piece of property. So you don't get a check in your account when you sell a property on a 1031 exchange. It's held with somebody else. And you have to tell them, hey, I want to buy that property over there. Can you do that for me? And they buy it on your behalf, along with you, basically. And they provide the funds out of the 1031 exchange money.
Wow. And how long do you have? What sort of window?
It's a very short period of time. So if I completed a 1031 exchange on January 1st, I have 45 days from that date to identify a piece of property that I want to buy. And I have 180 days from January 1st to close on that property.
Wow.
If I don't do that, it's going to be considered it's going to be considered basically a cash out, and I'm going to have to pay tax on everything.
Wow. Who are the players, the professional players involved?
Who you need in that situation? Yeah. Well, you definitely need a real estate agent that's going to be able to assist you in both the sale and the purchase of the new piece of property. You're going to need a competent escrow company. You'll need an attorney on your side, and you'll need an accommodator. The company that's going to hold the funds. And the attorney that you need can be a business or tax attorney. 1031 is not incredibly complex, but you need someone who is familiar with it. And if you're doing this as part of your divorce attorney needs to be very much involved as well to make sure that the implications of the failed 1031 exchange, because they can and do fail, are taken into consideration. So what happens if husband drags his feet and doesn't close within 180 days, and now he generated this huge tax liability? Well, we got to be prepared for that, and how do we offset what he screwed up in our negotiations, things like that.
Oh, wow. Who provides the accommodator? Because I've never even heard that term. So is this a professional that, for example, you as the attorney is going to say, point me in the right direction?
Yeah. So there are companies, that's all they do is they are professional accommodators. And it's the technical term for the person who holds the money as part of a 1031 exchange. So the escrow company is not the accommodator. They will work alongside that person or that company, but you'll need somebody.
Okay, very good. I think that was a really good overall big picture on 1031.
Because it could get extremely complex. So if you really are for a listener, if you're considering doing it, get somebody involved early. You don't do a 1031 exchange a week before closing. It's not going to happen. You have to be prepared for it ahead of time. Your escrow documents and your sale documents have to include that that's what you want to do. And
the bottom line is that you are deferring payment of taxes.
Correct.
Until a later time.
Until a later point.
Okay.
That's always the goal typically with taxes is to defer. You're almost never, with a few exceptions, going to completely eliminate taxes. You're trying to defer payment of taxes.
Perfect. Wonderful. So our next topic, itemized deductions and the impact on child and spousal support. This is just kind of a little tidbit that I wanted to talk with you about. So in family law, like I said, we have the Disomaster system. Yep. And the more deductions that you have, mortgage interest deduction, property taxes, the higher your child support figure is and your spousal support figure. And this is counterintuitive for our clients. They say, can you put in there that I pay this and I pay that and I have all these deductions? They're thinking, wow, so I have less money available to pay, for my support obligation. It's counterintuitive because, in fact, your child support and spousal support obligation goes up. What is happening here?
Well, I think what's happening, right, is, because, with the IRS, with the tax, you're always trying to show that you have all these deductions and you have all of these expenses and all of that. Much of that may not be counted in the Disomaster calculation, right? Just because you pay, $5,000 a month for a professional masseuse, Disomaster doesn't care about that, right? It's going to say, that's money available to put back into the house, right? You can absolutely pay support with that money, right? It's your problem that you do a $5,000 massage every month. So, the more that tax deductions you have is going to be more support because you're going to have more money available to you, right? So it does seem counterintuitive. It's, again, all the more reason to get the tax and divorce counsel involved early so that they can help guide you on that. Because if you haven't prepared your return for the next year, this may be an opportunity for you to say, I'm going to forgo those deductions, or I'm going to do a few things, some planning here to make sure my support is as low as possible or is where it needs to be, a reasonable figure, whatever the case may be.
So, the way I kind of explain this to clients is, we're talking about two different things. It's two different boxes. And one box is, all of the things that you're going to do for purposes of your tax return, for your tax planning to benefit you. Those exact same things, when you put those things into a DISO master or child and spousal support calculation, they're going to have the opposite effect.
Right.
So you really can't use the same arguments in both areas, which as a family law attorney, can get kind of tricky when you are arguing, when you want to argue a certain position.
Right.
So just that's to say that these deductions put more money in your pocket. Therefore, your child and spousal support obligation can go up.
Yep. That's exactly the way to think about it.
Okay. And then I understand that there are recent changes in the law and some caps on itemized deductions.
Yeah. So the law changed very recently related to just taxes generally. So it was at the beginning of last year. This will be the first year. 2019 will be the first tax year we're going to see the effect of these basically all the effect of this. But there's now a cap on mortgage interest deduction, a cap, what they call the SALT tax deduction, which is all your state and local income tax deductions. All of those things are being limited, and because of that, you're going to have more taxes that are going to be paid, more taxes are going to be owed. More and more people are taking the standard deduction instead of itemizing. So just the thing to think about there and to really keep an eye out for is that taxes will be changing, right? You may have always itemized, and this may be the first time that you won't itemize because it doesn't matter. The standard deduction is high enough, and forgive me for not knowing the exact figure, but it's around $26,000 that each individual gets as a standard deduction. It used to be much lower, $14,000. So, you can imagine that there's a lot more people that no longer need to itemize in that situation.
Very good. So I want to ask you about something that comes across here and there. You read about it. You read about it in the newspaper. I read about it in law school. It's called the innocent spouse defense. And I'll start off with a hypothetical. Husband runs a business. Husband and wife file joint taxes. But wife does not look at the return. She just signs it. Turns out husband has an egregious amount of expenses and deductions that probably won't fly. And he's not reporting a substantial amount of cash. So would you add or change anything in my hypothetical here?
The only thing I would add is no. Go ahead.
Okay.
And we'll run it through, and I'll mention what I was going to say.
Okay, perfect. So, generally, when we're talking about a situation where the IRS taps someone and says, "Okay, we're going to audit you," and one spouse is saying, "Well, I had no idea what was going on." So, innocent spouse defense. What is the innocent spouse defense?
Yeah, so innocent spouse as a rule is referred to as innocent spouse defense or innocent spouse relief. You may see both of those kind of used interchangeably. They're essentially the same thing. And it's where one spouse asks the IRS not to hold them responsible for taxes owed on a joint return, right? As at its simplest. And your hypothetical is perfect. It's the husband owns a business. Wife is checked out of that business. She's taking care of the family and the kids and all of that. And he says, "Hey, I laid the taxes on the dresser. Sign them before you go to bed." Right. And the next day she signs them. They're gone and doesn't hear anything more about it. Assumes that everything is hunky dory and great. Finds out as part of the divorce, or maybe what led to the divorce, that that's not actually the case. Right. That the husband's been underreporting or hasn't been paying the taxes is the most common scenario. And now the family unit joint returns that the wife signed off on owes $500,000 or $1 million in taxes, and the IRS is levying her bank account and his bank account and sending her audit notices and compelling her to show up for depositions and asking, "Hey, where's the money?" And rightfully so, she's freaking out. She didn't understand that this even, one, that the tax obligation even existed, or two, that she was wrapped up in it.
Right.
So innocent spouse is a procedure in which you ask the IRS to not hold one spouse responsible. In this case, it would be the wife. You would be asking, "Hey, look, while she signed the return, she had no idea all of this was going on." That sounds like a perfect solution, right? And everybody says, "Oh, great, this is for doing innocent spouse."
That's what I was going to say. That sounds just too easy, and it sounds like a floodgate situation where every single person's going to say, "Well, I had no idea. I had no idea." So tell me more. There have to be additional layers here.
There's a lot of layers, yeah. So what the IRS, first of all, the IRS hates saying that somebody doesn't owe taxes, right? The more people that are on the hook for the tax obligations, the more likely the IRS is going to get paid. So they take very seriously letting somebody legally out of an obligation that they created on taxes, right? So kind of keep that as your starting point. You're asking the IRS, who has a legal right to request this money from you, to say, we're going to pass. Okay, that's hard to do. You have to show there's many factors that have to be shown. And I have done many unsuccessful innocent spouse claims where we gave it a really good run and tried, and we had some facts to work with. And so I've done many of those, and I've had some success stories. And it really always is, it's very factually based. It's being determined by an individual in the innocent spouse department. So you have to really engage counsel. Innocent spouse is not something that you typically do on your own, right? Because there are certain triggering words that can help move your innocent spouse claim kind of a little farther into the process and hopefully towards an actual resolution and a successful resolution. If you just fill out the form and say, I didn't know that he owed this money and he lied to me all the time, that's going to get denied.
So, if I add to the hypothetical and I say, well, in addition to the facts I provided, the IRS investigates and it's determined that, husband gives wife a wad of cash every month and she uses that cash to pay the mortgage, to pay the children's private school tuition. Are these factors that are going to go against someone trying to make the claim?
They are. They're going to go against somebody. And there's all sorts of factors and everything. And like I was saying, it's very factual. So the IRS will look for any reason to try to disallow the claim. But factors just as easy as that the wife had access to see the bank accounts for the business, right? That could be a factor that says, no, we're not going to give you innocent spouse. You had reason to believe or reason to know that the accounts were negative, so you had to have known that he was making no money or whatever the fact may be, right? So yes, the husband giving the spouse a wad of cash, all those types of things will factor in. And I've also been on the other side of actually opposing a spouse's innocent spouse claim, where a spouse is saying, "Oh, I didn't know anything about it. I don't want to be held responsible." So then, an attorney like you will hire me to write an opposition to an innocent spouse claim, because because we don't want her off the hook or him off the hook, right? We want them to be jointly responsible for the taxes, especially if that's what the divorce decree says, because the IRS doesn't necessarily respect the divorce decrees or the agreement between the parties on the taxes, right? They have an independent ability to say, well, the divorce decree says the parties shall be jointly and severally responsible for the taxes. However, we're going to let the wife out. So in that situation, of course, somebody like you is going to go berserk and say, wait a minute, hold on. We have a divorce decree that says that you can't do that. Well, the IRS can. So, we will oppose in those circumstances and try to show all the evidence to support that the wife should have known that this liability was existing.
So I'll jump in and say this, and it doesn't matter how beautifully written your family law judgment is, the IRS doesn't have to conform to it. And that's why you really do need to have tax counsel involved to help you draft in a manner that's as consistent as possible.
Yes.
That's going to fly with the IRS.
That's beautiful advice, because you're exactly right. The IRS can sort of do whatever they want and within many circumstances, but they operate within a guideline, right? So if your divorce decree is silent as to something that the IRS would be looking for, or is counter what the IRS typical governance says on this, you're going to get filleted by them. So you have to, that's part of my job, is to say, okay, I'm going to help you draft these 6 provisions within this divorce decree to be something that the IRS would go, oh yeah, that makes sense, rubber stamp. And that's really kind of where that piece comes in. So that's again where it's important.
So Joshua, taxes aren't always fun, but give us a pro tip, or something for our listeners and viewers to take with them as a takeaway. What little nugget of information would you give them?
Yeah, I would say whether whoever your divorce counsel is or however you're handling it, get them connected to your tax person early, or talk to them about taxes early, because as we've talked about today, they're the silent killer, right, in any negotiation, because it's oftentimes after we've come to an agreement and everybody walks out going, okay, this is what we agreed to, that we start going, well, wait a minute, isn't that going to screw me up on taxes? So really start thinking about those early. That is the number one tip that I can give anybody, is involve, the tax person with your, introduce those two immediately so that they know what's going on, and make sometimes the divorce attorney won't always want to talk to the tax person. Really push them to connect, because, and you clearly get it from your perspective, like you understand the importance. Not every divorce attorney will, or they think it's outside their scope. So make, you as the client, you as the listener, really push and make sure that it's taken into consideration.
Wonderful. Joshua, thank you so much.
Of course.
Thank you for joining me. This has been
Absolutely.
wonderful. I hope that we have demystified some of these tax laws for our listeners and viewers. Thank you for joining me on Exhibit A. Until next time.